friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. This week, we will discuss a new book by Mary Ziegler. It's called Personhood, The New Civil War, and it explores the history and goals of the anti-abortion movement in the United States. To unpack the topic, we're putting her in conversation with a great scholar, Stephen Gilles, who's professor of law emeritus at the Quinnipiac University School of Law. He's written important law review articles and briefs on parental and reproductive rights. Stephen, it's wonderful to welcome you to We the People.
Thank you so much for having me, Jeff.
And Mary Ziegler is Martin Luther King Jr. Professor of Law at the UC Davis School of Law. She's written several critically acclaimed books on the law, history, and politics of reproduction in the United States. Mary, it's wonderful to welcome you back to We the People.
Thanks for having me.
Mary, one of the central arguments in your important new book is a historical one, and you argue that reversing Roe was never the real goal of the anti-abortion movement, but since the 1960s, the goal was to secure a concept of fetal personhood. And then you argue that the goal of fetal personhood has long united the various groups within the anti-abortion movement. Tell us more about your historical argument.
Yeah, so I think an important point to clarify at the beginning is what I mean by fetal personhood. So it's not simply the belief that life begins at conception or that life has value from the moment of conception. It's rather that life has constitutional rights from the moment of conception. So while there was certainly an earlier pro-life or anti-abortion movement in the 19th century, the one responsible really for the criminal laws that are on the books, that were on the books prior to Roe, some of which have sprung back into being since the reversal of Roe, that movement wasn't really talking about the Constitution. That's not surprising in some ways, in the way that the anti-abortion movement or pro-life movement really began to in the 1960s and has ever since. So often personhood is shorthand for the idea that the word person in the 14th Amendment applies to life from the moment an egg is fertilized, and that life has rights under the Due Process and Equal Protection Clause. That argument became kind of the glue in some ways that held the anti-abortion movement together from the 1960s onward, even as it remained in some ways kind of vague. That too was productive. It allowed people who disagreed on key questions involving everything from civil rights to corporate power to work together. At the same time, now that we've seen the demise of Roe, we're starting to see disagreements about what fetal personhood ought to mean and how it ought to be enforced break out into the open. So I thought it was important for people to understand that the end of Roe didn't settle the abortion conflict for supporters of abortion rights, to be sure. They're still battling on in the states. But it didn't really settle the abortion conflict for people who are opposed to abortion either, because the end game for them was never simply to let each state make its own decision. It was also, in some ways, to secure what people who are opposed to abortion see as civil rights for the unborn child or the fetus.
Thank you so much for that. Stephen, what's your view about Mary's argument that the central goal of the anti-abortion movement since the 1960s was to secure constitutional protection for fetal personhood, and that was not a goal of the 19th century anti-abortion movement?
Well, I think I'd start by saying that in the 19th century, the anti-abortion movement was riding high, winning in state after state, getting all those laws passed that Justice Alito relied on in Dobbs for the proposition that the 14th Amendment didn't recognize a right to abortion that would have been totally at odds with all the legislation that was passing in state after state between 1830 and 1890. They realized that they were in danger, as I think Mary does a great job of sort of summarizing the reactions of the pro-life movement as we get after World War II and the pro-choice movement really gets underway. The immediate objective was just to defend the existing laws. Once Roe hit, and here it's important to point out that Roe invalidated, at least in part, the abortion laws of every state and the District of Columbia. The pro-life movement, the sort of immediate goal became, let's get Roe overturned, but it's absolutely right that a core of the activists in the movement, as Mary shows, had the aspiration either of getting a human life amendment or of getting the court to reverse what amounts to not a holding, but let's say conclusion reached as part of the court's reasoning that indeed the unborn, and here I want to emphasize this, all the unborn, all the way through the end of pregnancy, none of them are 14th Amendment persons. And so for the pro-life movement, that was another big red flag, and it remains a red flag for many in the pro-life movement to this day. So I think Mary and I really agree about that. I want to say one more thing and then switch it back to her, or to you, Jeff. I don't think that it's accurate to say it's the dominant goal of the pro-life movement. It remains an important goal, but the pro-life movement is a big tent, and we can talk more about that.
Thanks so much for that. Mary, what are the legal consequences of what Stephen agrees broadly is the historical account, which is that the goal of protecting constitutional status for fetal personhood was essentially a post-World War II goal that, first of all, suggests that this is one of the most successful movements for civil rights of the post-war period, along with the women's movement and gay rights movement. It just descriptively is a right to say that this was quite effective. And then what are its legal consequences? Starting with the question of whether or not the 14th Amendment was originally intended to protect fetal personhood from the moment of conception.
Yeah, I think there's no question that the pro-life movement's been one of the most impactful civil rights movements of the second half of the 20th century. Successful is a harder thing to analyze if we're talking about 14th Amendment personhood, because, of course, the Supreme Court doesn't recognize 14th Amendment personhood. We've never come remotely close to ratification of a human life amendment. We have, at the moment, a Republican president and Republicans in control of both houses of Congress, and I think anyone would be shocked to see something like a Life at Conception Act referencing 14th Amendment personhood passing. Polls would suggest most Americans don't endorse 14th Amendment personhood. So I think the pro-life movement has created this kind of brilliant form of strategic incrementalism, patterned, unsurprisingly, on incrementalism used by other movements, I think most notably the NAACP and the lead up to Brown versus Board. But the trick with incrementalism for social movements is how you make the leap from achieving your incremental goals to achieving more sweeping, transformative goals that might be the reason lots of folks have mobilized to the movement in the first place. And I think, like many movements, the pro-life movement hasn't necessarily figured out how to do that yet, which is in some ways why I think there's been some frustration during the Trump years as to exactly what the next step ought to be. In terms of what enforcing personhood would look like, I think there's broad consensus that it would mean that liberal abortion laws would raise serious constitutional concerns because they would deprive an unborn person of due process, of equal protection, and so on. Once you get into the details, it turns out there are disagreements about what personhood might look like, even within the pro-life movement, and certainly as between the pro-life and pro-choice movement. Some of that, I think, is because until rather recently, 14th Amendment personhood wasn't something that anyone thought was achievable, even in under a state constitutional equivalent. And so there was sort of no need to hash out what would sometimes be difficult conversations about what personhood enforcement would look like. And it turns out that not everybody agrees on lots of particulars. As Stephen mentioned, the pro-life movement, like pretty much all social movements, is a big tent, and people don't agree. So I think exactly what it would mean on specific issues of contemporary importance, to pick one example, whether if a fetus or unborn child is a person, whether that would require potentially states to punish women for certain abortions. That's a subject of disagreement within the pro-life movement between folks, self-proclaimed abolitionists, and I guess you would probably call the mainstream of the pro-life movement. That's not something everyone agrees on. I don't know if or when agreement on those subjects will be fully fleshed out, right? But I think what's clear is that it would mean some federal constitutional challenge to liberal abortion laws and potentially laws on other things that threaten fetal life, right? Like potentially the current practice of in vitro fertilization, for example, potentially the current use of certain contraceptive drugs that some view as abortifacient. Like there are a number of things you could imagine being elevated to questions of constitutional concern. But again, I think the particulars are contested and a little ambiguous at this point.
Stephen, you've argued that as a matter of original public meaning, the 14th Amendment should not be construed to protect a constitutional protection for fetal personhood. Tell us why you've reached that conclusion and why you conclude at the same time that history and tradition does not support a right to choose elective abortion.
So in terms of the second part of that, I basically would just say, I think Justice Alito got it right in Dobbs in terms of his revised version of the history in which abortion, even before quickening, was always regarded as an unlawful act. It was not a criminal act, a common law, until after quickening. But that, as any torts professor will tell you, things can be unlawful and yet not criminal. And Alito relied heavily on what I already referred to, the groundswell of anti-abortion laws in the 19th century prior to the adoption of the 14th Amendment. That history, I think, is decisive with regard to whether or not there was a right to abortion of the kind that Justice Blackmun said had kind of been there at common law and in the United States all along until those statutes sort of temporarily displaced it. So I agree with Alito's history. I'm an originalist. I agree with his method of interpretation and the way he arrived at it. But then, as to the question of personhood, the court in Dobbs, the court carefully avoids discussing that issue, other than Justice Kavanaugh in the concurrence, I think signals pretty strongly that he would say that the unborn are not 14th Amendment persons. I reached that conclusion, although in addition to being an originalist, I do consider myself pro-life, anti-abortion, but I don't think that the personhood argument is correct. And the reason I don't think it's correct is that at common law, person was a term of art. It was a legal term, not just the word person in ordinary usage, which did indeed usually mean people, human being, any human being. But common law, you needed to be born for these rights of personhood that the common law gave to attach. And the most dramatic example of this is the born alive rule. If, for example, somebody just attacked a pregnant woman and the fetus died before it was born, that could not be murder because it had not been born. But if it was born and died from the injuries of the assault, that was murder. And the fact that the law of abortion was a heinous misdemeanor, not a felony. It wasn't a homicide offense. That I think tells us a lot. The unborn also did not have any rights in tort law, and even in property law, their rights were contingent on subsequent live birth. The courts would invent a sort of double fiction. You weren't alive until you were born, or a person until you were born, but we'll pretend that you were born back when the testator died. So all of that, I believe, was still largely in place at the time of the adoption of the 14th Amendment. And one final point. Why wouldn't this the most pro-life generation in history, including the legislators who proposed the 14th Amendment, why wouldn't they have wanted to constitutionalize this? Two reasons. One, because the states were already protecting the unborn more than they had ever been protected. And number two, because federalism was already the concerns that the 14th Amendment was going too far, right, to shift power to the federal government were already the centerpiece of the opposition to the amendment. And you would only aggravate that by moving into family law and domestic relations and federalizing that as well.
Mary, because you both agree that the focus of 19th century anti-abortion advocates was not fetal personhood. What do you think is the legal and constitutional implications of the fact that the 19th century common law understanding was that you needed to be born for the right to attach? It certainly suggests that the central focus of the anti-abortion movement changed in the 20th century. You describe in your book other goals of the 19th century movement, including protecting the interests of male doctors who were trying to distinguish themselves from midwives. Tell us about what the difference between those traditions was and what the legal consequences, in your view, are.
Yeah, I mean, I think the 19th century anti-abortion movement, I think absolutely was focused on a belief that life began at conception and that abortion was therefore a grievous harm. There were other things that anti-abortion leaders argued. Some of those things, the historical record would suggest, were said for reasons of expediency. So, in other words, to win over people who may not have cared about unborn life. For example, there were arguments about demography, concerns that Catholic women were having more children than Protestant women, and that was problematic for the future of the nation. There were arguments that abortion was essentially turning wives into prostitutes by making sex something that was done for pleasure rather than for procreation. And there were, I think, there have been historians, I'm not the original chronicler of this, to suggest that doctors were seeking a competitive advantage over other providers of care, like midwives, by establishing that they alone understood when life truly began and therefore what abortion truly involved. I think all of that was true. I think there was certainly an animating principle that life began at conception, too. Unsurprisingly, that Justice Alito in Dobbs dismisses the idea that there were any other arguments or any other motives. That strikes me as odd because movements, of course, have lots of figures, lots of motives, and sometimes arguments, again, that may not reflect the primary mobilizing agenda of the people in the movement, but that are there to try to win over converts. I think all of those things were in play in the 19th century anti-abortion movement. I think the other thing that's probably important to remember is that kind of rights consciousness and rights talk in the 19th century isn't what we've come to expect, right? Not only were there these concerns about federalism that Stephen mentions, there were also, I think, just not established conventions that there were enforceable rights that federal courts could identify and enforce against states in the way that we've come to expect now. And so if you were an anti-abortion or pro-life leader in the 19th century, it wasn't obvious that establishing a constitutional right would be the most powerful way to advance your cause. And so I think, in fact, you don't see legislators passing criminal laws talking about a constitutional imperative to do so. You don't see the laws being passed in a timeline that would suggest a constitutional imperative to do so. So I think all of that suggests that concerns about abortion were real and kind of ran the gamut from kind of gender paternalist concerns we would think are objectionable, or I would at least think are objectionable today, to concerns about unborn life that would sound familiar to someone in the anti-abortion movement and sympathetic to someone in the anti-abortion movement today. But I don't find that surprising because, again, you'd be hard-pressed to find a movement where absolutely everyone shares a singular goal, never makes another argument, or never holds another concern. I think you'd be hard-pressed to find any social movement in any history that actually fits that label.
Stephen, as Mary says, it's complicated, as it always is. The anti-abortion movement has had different goals at different times. Tell us about the significance of the fact that the common law did not view fetal life as deserving of legal protection from the moment of conception, and often embraced this quickening distinction that the abortion was more tolerated before fetal quickening. Was that because of a belief that life did not begin at the moment of conception, or a desire to balance the fetus interest against other reasons? What's the significance of the common law approach?
If you're looking for complicated topics, you found one. But look, Blackstone indicates that the law recognizes that the unborn have the basic right to life once the child stirs in the womb. That's quickening. So that was kind of a lay test, we can call it, that the law picked up on. If you can feel it moving, it must be alive. We know it's human, so we will at least protect it by criminalizing abortion. Again, not treating it as a person. So the birth line is still there. The unborn are not getting the same rights as infants who've been born, but they are getting what Alito calls in Dobbs the most fundamental right, the right to have one's life protected against not only the state, but against private violence. Now, that said, I want to respond a little bit to some of what Mary said about the pro-life movement. I agree with her that there were the coalition, the 19th century coalition. You can see doctors and others making a variety of arguments, but the central driving argument that was always made by sort of everybody was we now know that this is a new, distinct human being. And let me just say a quick word about this. Until the early 1800s, conception had never been observed. People speculated about what is it? When does life actually start? They knew there was sexual intercourse. They knew it could lead to pregnancy, but it wasn't until the 1830s that mammalian conception was observed, by a scientist. It wasn't until even after the 14th Amendment that sperm fertilizing an egg was observed in 1879. But once it hit in 1830, it quickly became accepted by the doctors who led the pro-life movement that this answers the question, when does a new human being come into existence? And then the Catholic Church weighed in by saying, yes, at conception, we think that the soul is infused. You put those things together, and here I want to just get back to what Mary said. When you look at all the different aspects of the movement, I think Alito was right to focus on the fetus. We recognize that the fetus has the right to life. We'll figure out which laws to do that, because, Mary, that's the through line. That's the line that ties together the behavior of Horatio Robinson Storer in the 1860s and the behavior of these pro-life law professors in the 1960s. It's the same argument.
Mary, do you agree with that, or do you think that the difference between the common law treatment of fetal life and that in the 1960s suggests that the tradition is complicated and perhaps there is some historical grounds for protecting the right to choose before fetal quickening?
Well, I mean, there certainly is a through line. I agree with Stephen about that. I mean, to some degree, that's kind of part of the thesis of my book, right? That there have been concerns about fetal life and fetal value, and then later about fetal rights that cut across what's otherwise a diverse movement. I think at the same time, you miss something by dismissing the complexity of the movement in the 19th century, or really now, right? I think, and that's the way, in some ways, the pro-life movement behaves when it finds someone in the pro-choice movement with objectionable motives, right? That's why we'll see lots of conversations about Margaret Sanger and eugenics, right? I don't think most people reasonably would argue that the through line for the pro-choice movement is Margaret Sanger and eugenics, but that doesn't stop people who are pro-life from saying we need to care when there are diverse movements that make arguments we find concerning. I don't think you found, there were people in the 60s making gender paternalist arguments too. So I think it's consequential when you see arguments that are not the consistent argument. As much as I think the movement has been focused in part, or in large part, on beliefs about unborn life, whatever else may animate those beliefs. And I'm sorry, Jeff, what was your other question? I know it's a two-part question.
Given the complexity of the tradition, some have argued that there should be constitutional protection for the right to choose abortion, at least before quickening, or do you think that the history supports that or not?
Well, I think at a minimum, Justice Alito's understanding of what tradition is somewhat problematic, right? So if we're going to do history and tradition, the court has never given us guidance on whose traditions count. And I think you've seen this in state courts that have dealt with history and tradition questions around abortion, because they've begun to ask, why is the only valid source of tradition state statutes or the views of physicians at a time when many Americans, including all of the Americans who would get pregnant or have abortions, were disenfranchised, right? So there's an interesting question about whether tradition should encompass custom, should encompass actual practice, should encompass the views of people in power as well as out of power, people who are protesting the law as well as endorsing the law. I don't think we have a satisfactory answer from the court about that question, but I'm troubled by the idea that tradition at a time when America was different in ways most of us don't find entirely popular, appropriate, or desirable, when only a small part of the nation was able to set policy at all, when we look only to the traditions set by those in power. So I think there's an argument that history and tradition should suggest some right to abortion. I'm not an originalist. I'm not really a 19th century historian. I think there's pretty strong evidence that there was certainly a custom of allowing access to abortion in cases of threats to life or health. This is something that Reva Siegel and I have written about in a piece in the Virginia Law Review. I haven't looked enough at the historical evidence as to other rights to abortion, but I think at a minimum that if we're going to take that task seriously, we need to look beyond just sort of counting statutes, which I think is primarily what Justice Alito does, although he consults common law authorities, he mentions Blackstone and so on. But I think a really robust account of tradition, which of course is somewhat different from original public meaning, a really robust account of tradition would have to be broader than the one Justice Alito gives.
Well, on that last point, Stephen, I think you agree with Mary because you've written an article in the Mississippi Law Journal, What Does Dobbs Mean for the Constitutional Right to a Life or Health-Preserving Abortion, where you argue that under Dobbs's own rationale, a right to life-preserving abortions should be regarded as fundamental, but a right to health-preserving abortion should not. Tell us about that argument.
So I think I want to qualify what you just said a little bit. I think my argument is that Dobbs, I properly understood, I think does imply that there's a right to a life-preserving abortion, a constitutional right. I think that right includes harms to health that would be, so to speak, on a par with threats to life. Those would be the most extreme kinds of harm. For example, putting someone in a permanent coma. But having said that, where do I get that from? Exactly from what Justice Alito relied on. All of those 19th century statutes and all the laws in effect at the time of Roe provided an exception for the life of the mother. And in a couple of jurisdictions by the time of Roe, there were much broader protections. But that the same tradition, put another way, no doctor or pharmacist, I think, that I'm aware of, was ever accused of having committed the crime of abortion in a case where it was agreed that the woman's life was in danger. But that, so having said that, if I may, I want to just return a little bit to what Mary is talking about with the tradition. I think there are certainly fair questions about what's the right way to do originalism. But I think that focusing on law and on the legal tradition is certainly the way that the court has framed that, not just in cases like Dobbs and Glucksberg, but when the court has done more living constitutionalist analysis, it has looked at how the laws have changed over time and at the movements in society more contextually that have led to those changes. Nevertheless, when you look at a case like Obergefell, it's the changing in society's attitudes that has borne fruit in changing the laws on which the court focused. So I think that Alito is right to focus overwhelmingly on law.
Mary, let's discuss other legal consequences of the really fascinating history that you discuss. As you note, feminists, including Pauli Murray, in the post-war period began to argue that restrictions on abortion violate the Equal Protection Clause because they promote gender stereotypes about women as caregivers. Justice Ruth Bader Ginsburg famously embraced this argument. And yet, in the Skermeti case, just this term, the U.S. Supreme Court reaffirmed a case called Geduldig and seemed to reject the whole anti-stereotyping premise of Justice Ginsburg's jurisprudence and suggest that the mere fact that a law promotes gender stereotypes is not enough to give it heightened scrutiny. First, do I have that right? And what is the really complicated and important history that you explore say about whether or not the court was right to reject the anti-stereotyping argument?
Yeah, I don't think that's quite what Scrimetti held, although I think that's where the court might be going, right? So groups like the Alliance Defending Freedom have long read, ironically, Justice Ginsburg's jurisprudence, in particular United States versus Virginia, to embrace the principle that the Equal Protection Clause provides that the sexes are not fungible, that there are enduring differences between the sexes, and that those differences are biological, and I would argue kind of fundamentally oriented around reproduction. And of course, that's interesting because some ADF and other groups like it were originally very unhappy with the decision of the United States versus Virginia, but they've since reread it to be a kind of celebration of biological difference. And I think the goal in some ways under Scrimetti was not to say simply that the law at issue in that case was constitutional, or to kind of reaffirm a reading and resurrection, really, of Geduldig that began in Dobbs and continued through Scrimetti. It was to establish that their sort of anti-stereotyping principle in Virginia was a thing of the past, and that Virginia was, in fact, about biological difference, not about the evils of generalizations and stereotypes about sex. Chief Justice Roberts in Scrimetti says, stereotypes are not okay, and essentially reaffirms that reading of Virginia, but then goes on to say that's not really what's happening here. And in fact, when he discusses Geduldig, he does so in the context of whether discrimination against transgender people is constitutionally problematic. It's not even just in the discussion of whether this is a problematic sex classification. Having said that, it's still notable to see Geduldig, which had been, I think, when I was in law school anyway, kind of a decision that no one liked, that pro-life and pro-choice people alike thought was kind of ridiculous and wrong, which is why they rallied together to pass the Pregnancy Discrimination Act in 1978. So to see Geduldig make this comeback and be central to many equality rulings in recent years has been, I think, jarring for me. And again, Geduldig has been, I think, in both Dobbs and Scrimetti, cementing this view that we can either assume that there is no stereotyping going on when in fact a classification is drawn on biological or reproductive difference. As Justice Alito says in Dobbs, a procedure that only one sex can get, or some other medical difference, as Scrimetti suggests. That's still happening. I think whether we go all the way to the kind of dismantling of Justice Ginsburg's anti-stereotyping jurisprudence remains to be seen. Of course, there are several cases about women's sports and transgender athletes that the court is set to hear next term that may pose this equal protection question more directly. And I certainly expect to see some conservative amici try again to read Virginia as being about a celebration of biological difference. But I think at the moment, we're kind of at a fork in the road in terms of how far the court is going to go in changing equality jurisprudence from what it had been when Justice Ginsburg was on the court.
Stephen, what is your view of Justice Ginsburg's anti-stereotyping argument and her conclusion that restrictions on abortion promote gender stereotypes and therefore violate the Equal Protection Clause? And what is your reading of the history, in particular the effort to protect fetal life, both in the 19th and 20th century? What does that say about an alternative basis or motive for anti-abortion laws that don't involve gender stereotyping?
Okay, so I think that I would say that even if you agree, and I think the court has not rejected the gender stereotyping argument. I think it said there are criteria that have to be met for a successful gender stereotyping argument, and we don't see any indication that they would be met in the case of abortion. And Mary's right, the court did rely on Geduldig at the beginning of Dobbs to just sort of dismiss an equal protection argument. I do not view that as a the beginning of a whole-scale revision of where Justice Ginsburg was able to lead the court, both as a lawyer and then as a justice. On the contrary, I think I would call it parallel to what happened with substantive due process in Dobbs, which is that the court demolished the right to abortion while making clear that it had no intention of transforming or eliminating the right, say, to gay marriage, or the right to contraception, or other substantive due process liberties. I think I would say the same thing here when it comes to equal protection, gender discrimination. Having said that, is there another convincing explanation for criminalizing abortion? I think that if we said in a future, a generation or two from now, when many, many, many pregnant persons are seeking abortion, and when let's say that's the dominant way in which society has come to view pregnancy, it's something that people, based on whatever their gender identity, some people get pregnant and other people don't, right? Would pro-lifers of every stripe still be saying abortion is wrong? Yes, they would, and for the same reason. It's taking the life of what they regard, right, as an innocent human being, an unborn child. That's not sex stereotyping.
Mary, anything else on sex stereotyping if you'd like, but I do want to turn now to this question of criminalization. You note that other countries, including South Korea and Germany, have recognized protection for fetal life without criminalizing abortions and suggest that that could be an approach for the U.S. Tell us about the debate about criminalization post-Dobbs.
Well, I think one of the sort of fascinating things about debate in the United States is if you look at polling, both by mainstream pollsters and by sociologists like Tricia Bruce, you'll see a fair number of Americans saying that they think life begins at conception and that life has value from the moment of conception, and then being opposed to criminal abortion laws. And that maybe you could just dismiss that as saying these are people who are not politically plugged in or who are just not getting it. But I think that there's something there in the sense that people may want to see other ways that government could honor fetal life that don't involve criminalizing abortion. That may seem, I think, puzzling, certainly to people in the pro-life movement. The 19th century expressed value for fetal life primarily by criminalizing abortion. Today, many of the debates about personhood are about precisely who and how abortion should be criminalized. They're not really about anything else. There's always been a strand, I think, even in the US anti-abortion movement or pro-life movement that has argued that if a fetus is a person, one way we may express that is by doing more to help pregnant people, right? Doing more to make abortion less attractive, what Jimmy Carter called alternatives to abortion, or support for new parents, or eliminating pregnancy discrimination at work. There are also questions, of course, about whether criminalizing abortion prevents abortion, which I think is a longstanding pro-choice talking point, but also one that, deserves some examination in a post-Dobbs world where abortion rates continue to increase in states, including those with bans, right? So I think there's an interesting question, one that's always been present in the U.S. abortion debate and remains so, which is that if you value fetal life, does that automatically mean that the best only, or perhaps not best and only for some people, but a necessary way to honor fetal life is through criminalization? I admit, as a kind of matter of normative priors, I don't find criminalization attractive as a way to do equality and justice across a lot of domains, and I'm skeptical of it being the best or only way to do justice for people who believe that fetal life has value here either. And I certainly think that moving into a debate about how else, if nothing else, how else we could do justice too, even for those who think criminalization is an important part of the picture, would be useful, as opposed to an ongoing, what seems to me, debate about how to criminalize, for example, cross-border conduct, whether to criminalize women who have abortions. I don't think that's a kind of debate that's going to build much consensus in the United States. I don't think it's a debate that captures what a lot of people in the middle already think. And it is a debate, too, that has made the United States in some ways kind of an outlier, although there are certainly other countries in the global south, other countries that have laws like the ones patterned on ours or those of the United Kingdom and Canada in the 19th century that criminalize that is still the way they do business. It's not the way a lot of other countries do. So I think it's worth considering whether this is the only way we can think about valuing unborn life, if that's in fact something lots of people in America agree ought to be done.
Stephen, tell us about your understanding of the debate about whether or not to criminalize abortion post-Dobbs. Are some states doing it? Is the anti-abortion movement united on this question or not? And what do you see the future bringing?
So since Dobbs, partly as a result of trigger laws that anticipated that Roe might be overruled, but also some new laws, there are now a sizable group of states with very restrictive abortion laws that allow abortions only to save the life of the mother or life of the mother in grave harm to the mother. Other states with very restrictive limits, like 6 weeks for unelective abortions. That is a substantial change in those jurisdictions. Other states, however, have gone in the opposite direction. States have, like Ohio, have basically reaffirmed with state referenda a regime very similar to Roe's, although not quite as permissive as Roe's in the case of Ohio. But the big point here, Jeff, is criminalize whose conduct. And Mary does an excellent job in her book of noting how it has always been a major question for the pro-life movement. What about criminal responsibility for the pregnant woman herself? And the answer that has been given in the United States throughout this century has overwhelmingly been effectively the pregnant woman is immune from criminal liability. The law does not apply to her. It's written so it doesn't apply to her. Or there's an express exception. That's true if she solicits the abortion, right? Or if she performs it. And not only is that still true with regard to the pro-life movement, but here's a remarkable fact. After the leak in Dobbs, the opinion was leaked, right? But before the final opinion actually came out, all the major pro-life organizations published an open letter to state lawmakers. I mean, all of them, all the big organizations. And here's the money quote. Women are victims of abortion and require our compassion and support, as well as ready access to counseling and social services in the days, weeks, and years following an abortion. As national and state pro-life organizations representing tens of millions of pro-lifers, let us be clear. We state unequivocally that we do not support any measure seeking to criminalize or punish women, and we stand firmly opposed to including such penalties in legislation. Now, there are two, so I think that's QED on where the movement as a whole is. However, Mary's right that if, as she and I agree is entirely unrealistic today, but if a Supreme Court in the future were somehow to say, yep, okay, we agree, the unborn are all from conception on are 14th Amendment persons, that would make it very difficult to defend this pro-life position, to say no criminal consequences whatsoever for the woman. I don't think that fear is realistic. And I think it's clear that even at the state level, the pro-life movement is not pursuing any possibility of liability for pregnant women. If they were, you would see proposed legislation for, say, a woman who leaves Idaho and goes to Illinois to have an abortion that destroys what the people of Idaho, based on their law, think is an innocent human being. There's no law to criminalize that, nor should there be.
Mary, tell us about other pressure point issues post-Dobbs. You described them in your last chapter. What are the major hot-button issues of debates, and how are the courts resolving them?
Yeah, I mean, I think there is a little bit more of a pressure point when it comes to punishing women than Stephen suggests, just in the sense that the abolitionists in the pro-life movement, they call themselves abolitionists, that's not my term, I think are more influential in some parts of the country than they were. Certainly, we are seeing bills to punish women for abortion being proposed in legislatures in lots of parts of the country. Those bills aren't passing, but they're I think in some ways abolitionists are having more influence behind the scenes. They're sometimes getting pro-life lawmakers to change the text of bills. We've seen that in some places, including Texas in the past legislative session. We've seen them exert a lot of influence over the Southern Baptist Convention, which has been pushing, I think, in the direction of embracing the idea that maybe it's okay to punish women. That hasn't happened yet. But I think part of the reason that all of those leading pro-life groups released that statement is because the statement is that conviction is under pressure in a way that it hasn't been before. I think that the mainstream view that punishing women is not okay is still prevailing. But I think it's under fire in a way that wasn't the case before Dobbs. I think, again, because of this embrace of 14th Amendment personhood and the challenge that raises for the idea that you can't or shouldn't punish women. There's, of course, quite a debate now about in vitro fertilization, particularly after the Alabama Supreme Court's decision of February 2024, about whether in vitro fertilization is incompatible with either valuing unborn life or with 14th Amendment personhood. There, you've seen a lot of leading pro-life groups, from the Heritage Foundation to Students for Life, calling for an overhaul of the way IVF is practiced in the United States. You've seen other abortion opponents raising the possibility perhaps that IVF just in general is wrong, not only that it needs to be reformed, but that it should just be abandoned altogether. That's, of course, consistent with some religious teachings on IVF across a number of faith communities. The Southern Baptist Convention recently took the position that IVF, as currently practiced, needs to be restricted or even prohibited in the name of treating unborn life better. So that's certainly another pressure point. We've seen concerns, again, about contraceptives, particularly emergency contraceptives, IUDs, potentially even the birth control pill that some folks in the pro-life movement view as abortifacients. I think that's a potential coming pressure point too. But again, I think because 14th Amendment personhood, if that's a direction the movement wants to go, is more all-encompassing, we'd see debates about fetal rights in arenas having nothing obvious to do with reproduction. So we've already seen debates in legislatures about things like child support during pregnancy, wrongful death suits. That was, of course, the question in Alabama, but in other domains as well. And who knows what else, right? I mean, Georgia's heartbeat law, which criminalizes abortion at 6 weeks, also is a personhood provision that determines how fetuses should be counted for census purposes as well as for child support purposes. So if we're really going down the road of defining personhood as beginning at a certain point in gestation, there would be questions really well beyond the ones I spotlight in my book, which I think have been the ones that have been a focus for abortion opponents to date, which are the ones that come closest to abortion in the sense that they're questions of reproduction. But I think we'd see many other questions raised if that's in fact a direction the law is going to go in the future.
Stephen, how would you describe the pressure points post-Dobbs? Mary has identified issues ranging from IVF to emergency contraception as those that the pro-life movement is debating. And broadly, do you believe that a majority of the movement will continue to press for 14th Amendment personhood, perhaps through a constitutional amendment or not? And is there majority support within the movement for constitutionalizing protection for fetal personhood?
I can't speak to a majority support within the movement. I think that the abolitionists represent a significant constituency within the pro-life movement. However, I believe not only that they have no chance of success given public opinion, the distribution of public opinion in the United States today. I believe that the movement's now that Roe has been overturned, Mary's right that this creates all kinds of new opportunities, but also challenges for the pro-life movement. And the pro-life movement has been trying to defend laws and lost. They're losing in referenda. So what to do about that? Whether to allocate more resources to education and persuasion, which I think would be appropriate. It is true when we talk about something like IVF, there is growing criticism within the pro-life movement, not of IVF as such, but of IVF as currently practiced, meaning creating surplus embryos. And so that Southern Baptist Convention resolution that Mary refers to is critical of IVF for that reason. It does not suggest that IVF should be prohibited. And we can tell from the public reaction in Alabama, there's no way that IVF is going to be prohibited in any American state, let alone through federal legislation. The question, the flip side of this, and I think where the pro-life movement may end up going more and more, is let's talk about subsidizing IVF based on eligibility for certain criteria so that the couple or the person can afford to do one embryo at a time instead of 3 or 5 or whatever the number is, so that you don't have millions of what the movement regards as unborn human beings sitting in cryogenic preservation. If we, the pro-lifers, think we should rescue those children, let's have embryo adoption and let's subsidize IVF that is more protective of embryos.
Well, it's time for closing thoughts in this very thoughtful conversation. Mary, first to you. You end the book by saying, even if majority support for abortion or IVF were genuine, few members of the movement intend to change course. It might take another generation to secure judicial recognition of fetal personhood, but that doesn't trouble the activists who successfully destroyed Roe v. Wade. They've played the long game before. What, finally, does the fascinating history that you discuss in Personhood tell us about the past and future of the pro-life movement?
Well, I think one of the things that was striking to me in studying this history is how much this history is bound up with the courts, really, because after all, it's no surprise because both the pro-choice and pro-life movements believe that they are fighting for human rights causes of our time. So the pro-life movement, to no one's surprise, does not see itself as primarily crafting positions to please the American public. It sees itself as fighting for important principles that transcend majority will. The irony, of course, is that when that's your position, you may have to rely on the very kind of judicial recognition of protections that you long, if you were the pro-life movement, denigrated, right, in condemning Roe for taking an issue away from the American people. But I think we've seen since the demise of Roe, pro-life groups returning pretty energetically to the courts, asking questions about everything from the FDA's authority to approve mifepristone to the interpretation of the Comstock Act. And certainly that will be the case, I think, for 14th Amendment personhood too. So while it may seem, I think, to me and to Stephen, that it's far-fetched to imagine 14th Amendment personhood going anywhere in a generation, I think if we were having this conversation about the demise of Roe in the year 2000, we might have thought that it was far-fetched that that would happen too. And again, the question is not whether Americans will come around to embrace 14th Amendment personhood. I find that pretty implausible. It's whether 5 justices on the Supreme Court will. And I was wrong publicly about the pace with which Roe would be taken apart. So I think it's worth paying attention because the pro-life movement has shown its ability to defy popular wisdom before, and I wouldn't be surprised to see it happen again. I think it's certainly something that people on both sides of this issue should watch closely.
Thanks so much for that. And Stephen, last word to you. What would you like we the people listeners to know about the past and future of the pro-life movement as Mary discusses it in her book?
So I think now that Roe has been overturned, it's true that there are some who continue to hope for either a Supreme Court ruling that all the unborn are persons or a constitutional amendment. I believe those hopes are legally unsound in the case of a new ruling about the 14th Amendment. And I believe they're practically impossible and likely undesirable in the case of a human life amendment. What we have is work state by state. And I believe that the pro-life movement will, over time, come around to making that its dominant focus. And I believe the basis for that shift, the argument for that shift, will be something that Mary did not spend much time on in her book, which is all the people in between the core pro-lifers, right? Abortion should be a crime all the way from fertilization, and the core pro-choicers who want abortion to be legitimate all the way through pregnancy. So many Americans are in the middle, and I think the pro-life movement is going to get to work on that.
Thank you so much, Mary Ziegler and Stephen Gilles, for a thoughtful, civil, and deep discussion of the past and future of the pro-life movement. Mary, Stephen, thank you so much for joining.
Thanks for having us.
My pleasure.
This episode was produced by Bill Pollack and Griffin Ritchie, who was engineered by Bill Pollack. Research was provided by Yuha Lee, Griffin Ritchie, Cooper Smith, Trey Sullivan, and Tristan Worsham. Please recommend the show to friends, colleagues, or anyone anywhere who's eager, hungry, and determined to enjoy a weekly dose of constitutional illumination and debate. Please check out the Constitution 101 course and anticipate eagerly, as all of us are, the new civic toolkit that the NCC is launching for America 250 in September. That's September 17th, Constitution Day, and it's going to be an extraordinary collection of America's greatest historians writing about the big principles of the American idea. And always remember that the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement. For all of our programming, please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.